After studying this module, you shall be able to know the mechanism for transfer of securities, learn the reliefs available in case of refusal by company to register transfer of securities, identify the need for emergence of depository system, evaluate the benefits of depository system, analyze the functioning of depository system.
Shares of a company are movable property and can be transferred by the shareholders in the manner prescribed under the Articles of Association. Right to transfer shares is absolute and inherent in the ownership of the shares. Articles of Association cannot absolutely take away the rights of members to transfer shares, thus making shares non-transferable. Shares of a public company are freely transferable as provided under Section 58 of the Act, whereas a private company is required to restrict the right of the members to transfer the shares. The Articles of Association of private companies contain the kind of restrictions on the transferability of shares. Generally, the restriction put by a private company is that of preemption, whereby the members are required to offer their shares first to the existing members of the company before offering them to outsiders.
Let us begin by understanding the free transferability of shares of a public company. Section 58 of the Companies Act provides that shares of a public company, both listed and non-listed, are freely transferable. A public company cannot put any restriction on transferability of shares. The boards of directors of a public company or a depository, in case shares are in demat form, cannot refuse or withhold transfer of securities. However, if the transfer of shares is in contravention of any of the provisions of the Securities and Exchange Board of India Act 1992 or regulations made there under or the Sikh Industrial Companies Special Provisions Act or any other law for the time being in force, then a depository, company, participant or investor or SEBI can prefer an application to the Company Law Board Tribunal after it is constituted to inquire about the contraventions. After conducting the inquiry, if the Company Law Board Tribunal is of the option that such contravention has taken place, it shall direct the depository or the company to rectify its register or record. Pending the inquiry, the Company Law Board Tribunal may suspend the voting rights of the transferee of shares. However, transferee will continue to have the right to receive dividend and bonus shares if declared by the company in the period pending inquiry. Transferee of shares may also transfer those shares to another person while the inquiry is pending. Refusal of transfer of shares. 1. If a private company limited by share refuses to register the transfer or the transmission of the right to any securities or interest of a member in the company, it shall, within a period of 30 days from the date on which the instrument of transfer or the intimation of such transmission was delivered to the company, send notice of the refusal to the transferor and the transferee, or to the person giving intimation of such transmission, giving reasons for such refusal. Second, the securities or other interest of any member in a public company shall be freely transferable, which means that any contract or arrangement between two or more persons in respect of transfer of securities shall be enforceable as a contract. Third, the transferee may appeal to the tribunal against the refusal within a period of 30 days from the date of receipt of the notice, or in case no notice has been sent by the company within a period of 60 days from the date on which the instrument of transfer or the intimation of transmission was delivered to the company. Fourth, if a public company without sufficient cause refuses to register the transfer of securities within a period of 30 days from the date on which the instrument of transfer or the intimation of transmission is delivered to the company, the transferee may, within a period of 60 days of such refusal, or where no intimation has been received from the company within 90 days of the delivery of the instrument of transfer or intimation of transmission, appeal to the tribunal. The tribunal may, after hearing the parties, either dismiss the appeal or, by order, A. direct that the transfer or transmission shall be registered by the company, and the company shall comply with such order within a period of 10 days of the receipt of the order, or B. direct rectification of the register and also direct the company to pay damages, if any, sustained by any party aggrieved. If a person contravenes the order of the tribunal under this section, he shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 3 years, and with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. Let us now discuss the process of transfer of shares. A company shall register a transfer of securities or interest of members only when such a proper instrument of transfer, duly stamped, dated, and executed by or on behalf of the transferor and transferee, and specifying the name, address, and occupation, has been delivered to the company by either party within a period of 60 days from date of execution, along with the certificate of security or the letter of allotment of securities, where instrument of transfer has been lost or has not been delivered, the company may register the transfer on an indemnity bond. On receipt of intimation, a company has power to register transmission of any right to securities by operation of law from any person to whom such right has been transmitted. Where an application is made by transferor alone and relates to partly paid shares, the transfer shall be registered by the company only after giving notice of the application to the transferee, and transferee gives no objection to the transfer within 2 weeks from the receipt of notice. The transfer of any security or other interest of a decreased person in a company made by his legal representative shall be valid as if he had been the holder at the time of the execution of the instrument of transfer. Every company shall, unless prohibited by any provision of law or any order of court, tribunal, or other authorities, deliver the certificate of all securities allotted, transferred, or transmitted. A. Within a period of 2 months from the date of incorporation, in case of subscriber to the memorandum. B. Within a period of 2 months from the date of allotment, in case of any allotment of any of its shares. Within a period of 1 month from the date of receipt by the company of the instrument of transfer or intimation of transmission. And D. Within a period of 6 months from the date of allotment in case of any allotment of debentures. However, where the securities are dealt with in the depository, the company shall intimate the details of allotment of securities to depository immediately on allotment of such securities. Our next topic is blank transfer of shares. Blank transfer means a transfer form signed by the transferor of shares and completed in all respect except the name and signatures of the transferee. It gives the right to the transferee of shares to get shares registered to himself or to transfer the shares to any person without undergoing the formalities of transfer of shares with respect to fresh transfer form and payment of stamp duty. A blank transfer can remain in circulation and valid only for a period of 60 days after it is signed by the prescribed authority, or the company closes its register of members, whichever is later. Transfer of shares on account of operation of law is termed transmission of shares. Transmission of shares occurs in case of death, insanity, or insolvency of an individual member, or if the member is a limited company on its liquidation. In all such cases, the legal representative, the administrator, or the official assignee or receiver, respectively, shall be entitled to the shares. It also includes devolution of title of the shares on account of constitutional changes. The person claiming the title to the shares has to make an application to the company for transfer of shares in his name. Formal instrument of transfer is not required, but the company may ask for probate, succession certificate, letter of administration, certificate of death, etc. The transfer of any security or other interest of a decreased person in a company made by his legal representative shall, even if the legal representative is not a holder thereof, be valid if he had been the holder at the time of the execution of the instrument of transfer. Section 56, subsection 5. He is also entitled to dividends declared by the company, but he is not entitled to vote at the meetings of the company. However, if the company's articles permit, the directors may withhold payments of dividend to compel a legal representative to elect whether he will or will not be a member of the company. A company can refuse to register a transmission if there is a provision to that effect in the articles, but the power must be exercised by the directors in good faith. The aggrieved party can appeal to the Company Law Board Tribunal for relief. Depository system. The process of physical transfer of certificates has many demerits. In absence of a depository system, every share transfer is required to be accomplished by physical movement of share certificates and registration with the company concerned. The process often involves long delay in settlements, and a significant portion of transactions end up as bad delivery due to faulty completion of paperwork, theft, forgery, mutilation of certificates, and other irregularities. The issuer has the right to refuse the transfer of a security. All this adds to cost and delay in settlement, restricted liquidity, and made investor grievance redressal time consuming and at times intractable. Thus, the limitation of having shares in physical form are high cost involved by ways of postal charges, stamp duty, cost on paperwork, etc. Depository system is a system where in the securities of investors are held in the electronic form with the depository at the request of the investors, and transfer of securities takes place by means of book entries on the ledger of depository. The system is also referred as the scripless trading system, as the system dispenses with the securities and its movement in the physical form. The features of depository system are securities in dematerialized form. Depository system provides for maintenance of ownership record of the securities of the investor in a book entry form. The system immobilizes physical securities so that there is no physical certificate in existence.
Fungibility. In the depository system, the securities dematerialized are not identified by distinctive numbers or certificate numbers as in the physical environment. Thus, all securities in the same class are identical and interchangeable. Parties involved are: in a depository system, the parties are the depository, 2. The depository participant, 3. The beneficial owner, and 4. The issuer. The depository renders service connected with the recording of allotment of securities or transfer of ownership of securities in its record. A depository functions through depository participants who are the agents of depository through whom the investors avail of depository services. In the depository system, the ownership of securities dematerialized is bifurcated between registered owner and beneficial owner. For the securities dematerialized, depository is the registered owner in the books of issuer, that is the company. Free transferability of shares. Transfer of shares held in dematerialized form takes place freely through electronic book entry system. The system dispenses with the transfer deed and other procedural requirements with respect to transfer of securities.
No stamp duty for transfer of securities in the electronic form is payable. In case of transfer of physical shares, stamp duty of 0.5% is payable on the market value of shares transferred. No risk. All risk associated with physical certificate such as delays, loss in transit, theft, bad deliveries, etc., eliminated in the depository system. Depositories curb the irregularities in the capital market and protect the interest of the investors and pave a way for an orderly conduct of the financial markets through the free transferability of securities with speed, accuracy, transparency, etc.
Let us now discuss the functioning of depository system. The depository system functions as: the system envisages setting up of one or more depositories to hold securities of investors in the electronic form. The depository functions through its agents who are called depository participants. The investor who wants to avail the services of the depository has to open a beneficiary account with depository through a DP. The account known as DMAT account can be opened with more than one DP. After opening the DMAT account, the investor is required to dematerialize the securities held by him in physical form. To dematerialize the securities, the investor has to fill the dematerialization request form called as the DRF form and submit the same to the DP along with the security certificate. The DP through the depository will intimate the company or the issuer and surrender the security certificate. The process known as dematerialization takes about 30 days. The issuer or the company, on receipt of the intimation, shall cancel the security certificate and substitute the name of the depository as the registered owner of the security. The depository, on being intimated by the company or issuer, enters the name of the investor in its record as the beneficial owner of the security. Whenever any rights, bonus or dividend is announced by a company for its particular security, the depository would furnish all details of the investors having electronic holdings of that security on the record date. The disbursement of the rights, dividends, etc. will be done by the company based on information provided. In case of sale of security under this mode, the investor or transferor, who is considered as the client, has to intimate the DP through issuing a delivery instruction slip called as DIS, duly signed and containing the details of security transaction. In case of purchase, the client will send the intimation to the DP giving details of the security purchased. The depository, on receiving the information through the DP, will register the transfer of securities in the name of transferee in its records. DP will also make book entries in the account of investor to record sale or purchase of securities. DP is required to send statement of account to the clients at regular intervals and update the account after each transaction. The client or investor has to pay charges to the depository and the DP for availing of the services. Slide 37. Registration of transfer of securities with depository. Every depository shall, on receipt of intimation from a participant, register the transfer of security in the name of the transferee. Further, if a beneficial owner or a transferee of any security seeks to have custody of such security, the depository shall inform the issuer accordingly. This is covered under section 7 of the Act. Options to receive security certificate or hold securities with depository. Every person subscribing to securities offered by an issuer shall have the option either to receive the security certificates or hold securities with a depository. This is covered under section 8 of the Companies Act. Securities in depositories to be held in fungible form. All securities held by a depository shall be dematerialized and shall be in a fungible form. This is covered under section 9 of the Act. Rights of depositories and beneficial owners. A depository shall be deemed to be the registered owner for the purposes of effecting transfer of ownership of security on behalf of a beneficial owner. The depository as a registered owner shall not have any voting rights or any other rights in respect of securities held by it. The beneficial owner shall be entitled to all the rights and benefits and be subjected to all the liabilities in respect of his securities held by a depository. This is covered under section 10 of the Companies Act. Register of beneficial owners. Every depository shall maintain a register and an index of beneficial owners in the manner provided in section 150, section 151 and section 152 of the Companies Act 1956.
The benefits of depository system are: bad deliveries are almost eliminated. The risk associated with physical certificates such as loss, theft, mutilation of certificate, etc., are eliminated. It eliminates handling of huge volumes of paperwork. There is immediate transfer and registration of the securities at the end of every settlement cycle, which is for working days, that is T plus 3, and you need not have to suffer delays on account of processing time. It leads to faster settlement cycle and faster realization of sale proceeds, so the fund of the investor is not tied up unnecessarily. The system facilitates a faster disbursement of security holding benefits like right shares, bonus shares, etc. The stamp duty on transfer of securities, which is 0.25% of the consideration on transfer of shares in physical form, is not applicable. Availability of periodical status report to investors on their holding and transactions is disseminated by the Depository. The Depositories Act 1996. The Depository Act 1996, which came into force from 20th September 1995, provides a legal framework for establishment of depositories to facilitate holding of securities, including shares, in the demat form, electronic form, and to effect transfer of shares through book entry in accounts maintained by the depository. Rights and obligation. Agreement between depository and participant. As per section 4, a depository shall enter into an agreement with one or more participants as its agent in the prescribed form. Services of depository. Any person, through a participant, may enter an agreement in such form as may be specified by the bylaws with any depository for availing its services. Section 5. Surrender of certificate of security. A. Any person who has entered into an agreement with the depository will have to surrender the certificate of security for which he seeks to avail the services of a depository to the issuer. B. The issuer, on receipt of certificate of security, shall cancel the certificate of security and substitute in its records the name of the depository as a registered owner in respect of that security and inform the depository accordingly. And C. The depository thereafter will enter the name of the person referred.
Shares of a public company are freely transferable, whereas private company is required to restrict right of the members to transfer the shares. A company shall register a transfer of shares when a proper instrument of transfer, duly stamped, dated and executed by or on behalf of the transferor and the transferee, is delivered to the company by either party within a period of 60 days from the date of execution. along with certificate of security or the letter of allotment of securities. Blank transfer means a transfer form signed by the transferor of shares and completed in all respects except the name and signatures of the transferee. Transfer of shares on account of operation of law is termed as transmission of shares. Depository system is a system wherein the securities of investors are held in electronic form with the depository at the request of investors, and transfer of securities takes place by means of book entries on the ledger of the depository. The Depositories Act 1996, which came into force on 20th September 1995, provides a legal framework for establishment of depositories to facilitate holding of securities, including shares in demat forms, that is electronic form, and to effect transfer of shares through book entry.
Pledge or hypothecation of securities held in a depository. A beneficial owner may, with the previous approval of the depository, create a pledge or hypothecation in respect of a security owned by him through a depository. Every beneficial owner shall give intimation of such pledge or hypothecation to the depository, and such depository shall thereupon make entries in its record accordingly. Section 12. Furnishing of information and records by depository and issuer. Every depository is required to furnish to the issuer information about the transfer of securities in the name of beneficial owners at such intervals and in such manner as may be specified by the bylaws. Every issuer also has to make available to the depository copies of the relevant records in respect of securities held by such depository. Section 13. Option to opt out in respect of any security. If a beneficial owner seeks to opt out of a depository in respect of any security, he shall inform the depository accordingly, who will make appropriate entries in its record and shall inform the issuer. Section 14. Depositories to indemnify loss in certain cases. The depository shall have to indemnify any loss caused to the beneficial owner due to its negligence or the participant. Where the loss due to the negligence of the participant is indemnified by the depository, the depositor shall have the right to recover the same from such participant. Systems and procedures. Every depository shall have systems and procedures which will enable it to coordinate with the issuer or its agent and the participants to reconcile the records of the ownership of securities with the issuer or its agent, as the case may be, and with the participants on a daily basis. Regulation 30 of SEBI regulations. Internal monitoring, review, and evaluation of systems and controls. Every depository shall have adequate mechanisms for the purposes of reviewing, monitoring, and evaluating the depository's controls, systems, procedures, and safeguards.